Rub-a-dub-dub. Time to get that thing started. Ladies and gentlemen, welcome to the Saturday show. This is Court Gallery, and I am your host, Lone Wolf Ousel. Today we have a full show in store for you. We're going to start off with Judge Ricky, who's sentencing a crazy guy with a pendants to stick ice picks in his grandmother's skull. And ladies and gentlemen, Grandma's okay. She's in court. It's an interesting case, though. I just want to see how it all works out. I haven't seen this whole one, but this one's more for me than for anybody else. Then we're moving directly from Kansas, back going over to Michigan with Judge Simpson, where he's got a probable cause case for a police officer who seems to have lost the script on what it is to be a police officer. And we're going to hear all about that, and we're going to hear from a faux lawyer that has some things that need to be said to her. But right now, ladies and gentlemen, things are getting started. Let's do this thing, shall we?
Welcome into 12 News at 10. I'm Rachel Hackbar.
And I'm Michael Schwenke. Tonight, new reaction from the family of an Augusta man charged with attempted murder of his 70-year-old grandmother.
Gage Apple is now in jail, accused of stabbing his grandmother. Brandon Stitt talked with the father, who is also the son of that 70-year-old woman.
A frantic call Friday afternoon to Augusta Public Safety.
Getting a lot of screaming in the background, and someone's trying to kill his grandma.
Police say this man, 30-year-old Gage Apple, stabbed his 70-year-old grandmother.
Has an ice pick stuck in the skull.
Rhonda Schwind lives next door.
And she loves her grandkids. They come from a very large family.
Apple arrested a short time later about a mile from this home, where he lives with his grandmother. Grandma, now expected to be okay. Her son telling me she was released from the hospital to a rehab facility. That son also the father of Apple, saying Apple suffers from bipolar disorder and schizophrenia, adding that a recent medication change may have prompted Friday's stabbing.
I feel bad for both sides, you know. I mean, that's your grandson.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Gage Douglas Apple. It's case number 2024 CR 341. Brett Sweeney appears on behalf of the state of Kansas. Chris Pate as defense counsel. Defendant Gage Apple appears from a Zoom location at the Butler County Detention Facility. This matter comes before the court at this time for sentencing. Court's docket notes indicate that on January 21 of 2025, Mr. Apple appeared before this court and pled no contest to an amended count 1, aggravated battery, a level 4 person felony, and count 2, aggravated assault, a level 7 person felony. A pre-sentence report was ordered and sentencing set for today. Court has received a completed pre-sentence report compiled by pre-sentence investigator Ryan Smith, who is present on this meeting with us. I trust each attorney has received a copy of the report, and I'll ask the state if they have any objection to the criminal history as stated therein.
No objection, Your Honor.
And I trust no objection by the defense, Mr. Pate?
No objection, Your Honor, and I did discuss that with Mr. Apple prior to today.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed further accordingly. Court will ask at this time, Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in the Apple case this afternoon?
I know of none, Your Honor.
Mr. Pate, are you aware of any such legal reason?
I know of no reason, Your Honor.
Mr. Apple, do you know of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, sir.
Court will proceed further then. Counsel, I am aware that there's been a motion for a departure sentence filed by the defense in this case. Court is familiar with its contents. Mr. Pate, you may proceed further in regards to that motion for a departure sentence.
Thank you, Your Honor. In this case, obviously our recommendation would be that the court grant a dispositional departure and place Mr. Apple on community corrections probation for a period of 36 months. I've really stated out all the reasons for that in the motion. I did also, prior to this hearing, submit to the court a letter from the Butler County Jail from the Getting Ahead class showing programming that Mr. Apple had participated in. I submitted a psychological evaluation to the court dated December 26, 2024 that Dr. Jared Steffen completed. And I also sent a letter from Cynthia Suter, who is Mr. Apple's grandmother, dated February 25th, written in support of him. She's a retired circuit judge from Missouri. I would also, as I'm sure the court and counsel has seen, just direct everyone's attention to the letter that one of the victims, Patricia Apple, wrote that's also attached to the pre-sentence investigation. I think that the biggest thing here, and I think Dr. Steffen does a really good job of setting it out in his evaluation. Mr. Apple is not, I guess, the typical criminal defendant that we see, especially in a violent person crime type of situation. He was 30 when this happened. He had no criminal history whatsoever. He does have some pretty serious mental health issues. He's been diagnosed with bipolar disorder. I think if you review the affidavit in this case and you review the evaluation, Mr. Apple was clearly not in a good state of mind when this occurred. I think he was hearing voices. Specifically, Dr. Steffen noted that his psychotic and manic mental state adversely affected his abilities to perceive, judge, reason, and control his behavior in a rational manner. Mr. Apple was experiencing extreme mental and emotional disturbances that substantially impaired his capacity for judgment and to conform his conduct to the requirements of law. That is one of the non-exclusive departure factors that's specifically set forth in KSA 216815. I think it's important to note Dr. Steffen did not have the opinion, and we are not arguing that this is a mental disease or defect case where Mr. Apple did not have the ability to understand the difference between right or wrong. We're not making that statement. The report does not establish that. I think Mr. Apple understands and understood the criminality of his conduct. I think he was just in such a bad mental state that it made it difficult to conform his conduct to the requirements of law. So I think that's supportive of the specifically enumerated departure factor. As I said, he's also engaged in programming in the Butler County Jail. He completed the Getting Ahead While Getting Out class, which was a 10-week program. Ms. Apple, the victim in the case, wishes for Gage Apple to get mental health treatment rather than a prison sentence. I don't think Mr. Apple is an inherently bad or dangerous or violent person. I think he's an individual with severe mental health issues that is going to need treatment, and he's going to need medication, and that's going to exist whether he gets probation today or whether he goes to prison for several years and gets out and he's on post release. He's going to need that to be successful. I think given his mental state, I think he's probably going to be subject to manipulation and victimization in prison as well, more than the typical inmate. I know Mr. Apple has indicated to me that he wants to get back in programming with South Central Mental Health. He's willing to follow the recommendations that Dr. Steffen has set forth, which include completing an anger management program and domestic violence treatment program, and also to engage in substance abuse treatment. Mr. Apple does have a history of some substance abuse, and like we often see, I think when you combine the substance abuse and the mental health, it exacerbates those issues, it complicates them. So it's going to be absolutely critical that he stay sober and get the treatment necessary to do that. I would note to that end, he's served 236 days in jail, so almost 8 months. That's, number one, been a substantial sanction and restriction on his freedom, especially for a person that is 30 years old and doesn't have any criminal history. It's also been a substantial period of forced sobriety. And I think rather than just sitting there and twiddling his thumbs, I think he's been trying to do everything he can to better himself, so when he does get out, he would be successful. So for those reasons, Your Honor, we're asking the court consider imposing probation. If the court does that and wants to give Mr. Apple a lengthy underlying sentence, I think that would be appropriate and understandable. If for some reason the court does not grant probation, our formal request would be for counts 1 and 2 to run concurrent, and the court to also consider a durational departure. But as I said, our primary request is a dispositional departure, and if the court grants that, we think whatever underlying sentence the court deems appropriate is acceptable to the defense.
Page, several questions arise. Let's look at it first from a question of statutory authority. This is a presumptive prison case. What mental health confined facility exists that this court has the authority to make a direct placement into?
I don't necessarily think there's a confined facility that's available to him immediately. I think if he did have one available, I think the court could order him to do that as a condition of his probation. I'm not aware that there's a bed waiting for him, and that wasn't necessarily our request that he be sent to a confined mental health facility. We were thinking more along the lines of medication management, getting back in with South Central Mental Health, going to therapy, taking substance abuse treatment, and things of those nature. But I do think if there was a confined mental health facility available and he was ordered to complete that as a condition of probation, I think he would be more than willing to do that. I think that would be much more beneficial to Mr. Apple than prison for a number of reasons that I've already stated.
And how would this court be assured that there is such a facility that would accept Mr. Apple?
I don't think there's any
direct placement. Then how am I assured that he will ever go to such facility?
Well, I think he would have to make application to such a facility. I think in that case, the court could order up to a 60-day jail sanction prospectively from today to allow time for that to take place. And then once a bed is available, grant parole from those 60 days or allow him to go just simply at the expiration of 60 days.
All right. I'm also concerned here, Mr. Pate. Obviously, the underlying facts of this case is that Mr. Apple stabbed his grandmother multiple times in the face and head area. In fact, embedded an ice pick into her skull at one point. An extremely violent offense in which the victim herself called evil. This court agrees. So how does your plan, which is essentially a release Mr. Apple into the community, how does that protect society, Mr. Pate?
Your Honor, if he's maintaining sobriety, if he's engaging in treatment, if he's following recommended medication management, I think those safeguards would ensure community safety. I think from what I see, his actions here were a product of a severe mental disturbance. I think you look at an individual who's 30 years of age, he has no prior criminal history at all. Usually in the typical violent person felony case that I see, you usually see a long criminal history where a person has escalated from minor drug offenses, property offenses on up, and then they graduate up to really serious things like this. I would say in my experience, it's a very, very, very rare case where you see a person that's 30 years of age with a clean record that just starts off with an aggravated battery that was originally charged as an attempted murder, unless it's a crime of passion or something like that, which this isn't. I think it was a product of Mr. Apple hallucinating, hearing voices and things of that nature. So I think his history would dictate if we're managing the mental health thing of this very, very closely, that he's not a person that's likely to commit repeat violent offenses.
Very well, Mr. Pate. Mr. Sweeney, what is the state's position regarding this departure request?
Your Honor, the state stands in opposition of the departure request. I'm in receipt of all of the documentation that Mr. Pate has referenced regarding Dr. Steffen's report. And I don't deny, or I don't take issue with the fact that he may and probably did have some mental health issues going on at the time, maybe exacerbated by some drug usage. But that's something that we see in a lot of defendants that come through this court and other courts. And it doesn't absolve them or at least it shouldn't, from an appropriate punishment. And given the incredibly violent, brutal nature the courts addressed, what the facts of this case were, an ice pick that was used to attack his grandmother on or about her face and in her head. It's incredibly violent. And I would note and acknowledge, because I've seen the documentation from Miss Apple, and we've had contact with Miss Patricia Apple, that she wants a probationary or rehabilitative order from this court. And I can certainly appreciate that as his grandma. She loves her grandson, but I have to look at the public safety at large, and just given the incredibly violent nature of this offense, I don't think public safety is benefited if he's given a non-prison sentence. So the state would be asking for the prison sentence to be imposed, and would stand in opposition to dispositional and or durational departure.
I understand the state's position, Mr. Sweeney. Mr. Pate, anything further regarding your request for a departure sentence? I will be asking you for formal recommendations later, but anything else on the departure?
Not as to the departure, Your Honor.
Very well. Thank you. The court will ask at this time then, are there any victims present who desire to address the court in relation to this sentencing? Patricia, do you wish to address the court?
Yes, I do.
All right. You may make your statement at this time.
I want to start by thanking you, Judge Rickey, for giving me the opportunity to speak and for the professional manner in which you've handled the difficult aspect of this case. But also the respect you've shown Gage throughout. Those who've known Gage for over the years would never have believed him capable of doing what he did on July 24th, 1924. It was a shock to everyone. Gage has always showed me nothing but love and respect. If it wasn't for mental health reasons, I know in my heart we wouldn't be here today. The version of Gage present that day was not my grandson. The look in his eyes were the most completely lost, and it seemed as if he didn't even know who I was. For 30 years, Gage has been nothing but good to me, and breaks my heart that he couldn't get the sufficient help he needed through the attempts, even though he had made attempts with Butler County Mental Health. I'm sharing this in hopes that you will consider giving him concurrent sentence so that Gage will be one step closer to getting proper help he needs. I also ask that the contact with me won't be restricted anymore. For having the family support through the time is very important. I do also want to take a moment to make it known how proud I am of my two youngest grandsons who were outside of the house during the incident. It weighs heavy on my heart for what the boys went through that day, and forever be thankful for the help that my two little heroes got me. Now it's time for our family to heal, and I just pray you do the right thing for Gage. Thank you for listening.
Thank you for your statement, Ms. Apple. Finding no other persons to address the court in relation to this sentencing in the nature of victims or victims' family members, court noting, the court has received some written document submissions that have been referred to earlier, which the court has and will consider. The court at this time will ask counsel for their formal recommendations regarding an appropriate sentence for Mr. Apple, beginning with Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, with respect to count one, the state would recommend the standard and mid-box 41 months and DOC. With respect to count two, the state would recommend the standard and mid-box 12 months and DOC. We would acknowledge he does have 236 days of jail time credit. He would have a 15% maximum good time percentage on count number one, as well as 20% on count number two. He would have a post-release supervision duration of 36 months on count number one. Your Honor, pursuant to the plea agreement, we're not seeking any fine in this case. We are, of course, seeking the court costs, attorneys and bids fees if the court would find appropriate. And this is a first-time felony, so the state's seeking a DNA fee. This is, of course, a registration offense. I know he's been in custody, but I do think that needs to be addressed. As far as no contact with the victim, his grandmother. Obviously, the state's asking for prison. I don't know that the state would have. I mean, if he's being sent to prison, I guess that's kind of out of the court's hands. But I don't know that the state would have any objection to him having contact with her inside the confines of Kansas Department of Corrections. Given the nature of the plea agreement, I don't think I have any further recommendations.
Very well. Thank you, Mr. Sweeney. Mr. Pate, your formal recommendations regarding an appropriate sentence.
Your Honor, our primary recommendation would be the court grant the departure, place Mr. Apple on community corrections for a period of 36 months with 15% good time on count one, 20% good time on count two if prison is imposed, and then 36 months of post-release. We agree he would be entitled to 236 days of jail credit. In the event the court grants the departure, we would leave the underlying sentence to the discretion of the court, whether the court thought concurrent or consecutive was appropriate. In the event that the court thinks prison is appropriate, we would ask the court to consider a durational departure to an appropriate sentence less than the mitigated number of 38 months on count one, with count two to run concurrent. In the event the court does not think a durational departure is appropriate, we would ask for 38 months on count one, with count two to run concurrent with a 12-month sentence, I suppose. I think I already said it. In that case, there'd be 15% good time count one, 20% good time count two, and then 36 months of post-release.
And your fees in the representation of this client, Mr. Pate?
They're approximately $2,200, so I think that's at a level where I'm going to have to ask for an exceptional order.
Very well. Understood, Mr. Pate. You've articulated your position and the position of your client well, Mr. Pate. I'll now turn to Mr. Apple himself, and I'll ask the defendant if he has any statements that he wishes to make on his own behalf in mitigation of punishment, or Mr. Apple, anything else that you wish to present to the court.
Yes, sir. If you don't mind.
Okay.
Okay. Bear with me. The first one that I have, if it's okay, I want to start out with an apology to my grandma. I know everyone knows her as my Nana, but I just wanted to say this to you. This is from my Nana, Patty Apple, and anyone else affected in this case. I am so sorry that there aren't words to describe how truly sorry I am. I pray for you all day and every day. This trauma has changed our lives forever, but I hope you can forgive me one day. I'll never be able to forgive myself. I'm haunted by this event every day forever. You are my best friend, someone who I can talk to and share memories with. You've raised me, and I would never imagine causing you or anyone any harm. That day, I felt a huge part of myself died. The anger took over, and I felt I was a little possessed. I'm not sure how, but I want a life, a chance at life. And I'll do whatever it takes to have another chance. God, I need you now more than ever. My deepest apologies. God bless you, and I hope you are well, Nana. And then I just wanted to read this for the courts. Thank you, Your Honor, for hearing me out and allowing me to say a few things on my own behalf. Growing up, I found myself associated with people who exhibited some unhealthy negative behaviors that led to my own struggles in my own life and my mental health. In 2018, I sought out a way to get off the alcohol and attempt to break the chains of my addiction. I started seeing a med provider on a monthly basis where I was ultimately diagnosed with anxiety, depression, the major depressive disorder, bipolar, mania, meds for PTSD. This gave me perspective on how much I needed treatment. Living all my life up to that point undiagnosed made me aware of how much this has affected my own life as well as those around me. My clean date from my drug of choice is June 21st, 2018. In jail, I have participated in the AA groups, the Thrive reentry class, and Bible study on a weekly basis. I've put together some contact information for Oxford houses and halfway houses, as well as jobs in the area that hire people with a record. Wichita workforce, temp agencies, and support groups. Upon release, I plan to work ASAP and open to school to better myself for the future. I have some previous employers that I will reapply for, such as Walmart and Sam's Club. Within the first 3 months of being released, I will have ordered a driver's license and other documents to help me get a job. Once I know more about a sentencing and potential release date, I can reach out to all of these resources listed above, which would include like bed dates at the Oxford houses and what their immediate availability would be to have me move in as a tenant. Thank you for hearing me out once more. And I do want to state that since I've been here at the jail, I have continued to make my medical lady down here, the nurse down here, she has been in constant dealings with my doctor at South Central Mental Health. She's the one who advocated to get me put back on the medications and stuff like that. And, after last year, I was weaning off and then getting back on the medications. Then I ended up in the hospital for 15 days in their psych unit. And, that was because I was getting off the meds. Thankfully, I've been able to get back on those meds and have them monitored by psychiatrists in Wichita. I don't know all the list of the names, but I see someone, at first it was on a weekly basis, sometimes more than once, but still up to this point on a regular basis. The only thing that I could think of would be Good Shepherd, but that's not really a place that's going to do anything more than, I've been there a few times before for like detox and getting put on medications. But long term, since I have all the medications and stuff that I was on prior to, I'm back and I've been stabilized. When I got to the jail here, I weighed 106 pounds. They immediately put me on 24-hour watch because my body mass index was so low. And since then, I weighed in a couple of days ago, this last week, I weighed in 143 pounds. I have never been this healthy in my life. And the support that I have here at the jail has been astounding. So I just wanted to say thank you for hearing me out. And I just wanted to say, because I haven't seen her face, I am so sorry and I love you so much. I just want to hug you. I just want to hug you. Because tomorrow was never promised and I hate this. Oh, I'm supposed to be home with you, taking care of you. And I'm so sorry to you and I'm so sorry to the boys. It's just an awful thing. So I'm so glad you were able to be here. Anyways, I hope you're safe. I hope you're well. I hope all the good things. And I know that I don't have any words. Nana, you don't deserve this from me or anyone. And I'm so sorry. I am so, so sorry.
All right, Mr. Apple. The court's ready to pronounce sentence in your case. The court's giving you some latitude at the end of your statement to make some statements of apology to Patricia Apple, your grandmother, which she's certainly entitled to under the circumstances of this case, and I'll give you a certain amount of credit for doing so. Mr. Apple, I tend to agree with what Patricia once labeled your acts as, and that is evil. Somewhere there was an evil in you that was unleashed that day that caused you to take an ice pick and try to stick it through your grandmother's eyes and lodge that ice pick into her head after multiple stab wounds. That is not threatened harm. That is very, very serious actual harm that was done to another human being, especially one that you had every reason to love. What a sweet lady she is. To come to court and advocate for you after what you did to her. What a wonderful woman. She deserved better than the treatment you gave her that day. The court has to judge your actions here. And I will say, Mr. Apple, after everything's been presented, and I've read everything that's been presented to the court, that the court wishes to show you mercy. The court wishes to show you compassion. This court also has to weigh, however, your threat to society, which the court considers to be considerable, even as we speak. The court will go ahead and start pronouncing its sentence at this time. The court hereby establishes count 1 as the base sentence in this case for the offense of aggravated battery, a severity level 4, non-drug, person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 4I. The court hereby sentences the defendant to a term of 38 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. No fine is imposed. Regarding count 2, for the additional offense of aggravated assault committed with a deadly weapon, based on court finding that the ice pick used in this case was a deadly weapon. The court finds that this is a severity level 7, non-drug person felony. The court imposes 12 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant is eligible to receive 20% of good time credit and would be subject to 12 months post-release supervision on that charge and charge alone. However, the court will at this time run the counts and the time on counts 1 and 2 concurrently with one another. So there is a controlling sentence in this case of 38 months. Mr. Apple, your attorney, as I stated earlier, and sorry about the loss of video, that was unintended. Your attorney's argued well on your behalf for a departure. I do note all of the statements in support, including your grandmother, Patricia. However, this court, despite its wanting to show you mercy and compassion, also has to look, as I stated earlier, on the protection of society. For this probation plan that Mr. Pate argues for today to work, a lot of voluntary things would have to take place where this court would have to count on your willingness and consistency in performing those things. There are issues about where you would live, where you would work, what kind of treatment program you'd be in, and whether you would voluntarily participate in a long-term mental health treatment program and take the medications that have been prescribed, especially with your long history of substance abuse. These all, in this court's view, create problems with any probation program that might be established. This court is bothered tremendously, Mr. Apple, and this is not necessarily your fault, that the Department of Corrections does not have a facility that is centered solely on mental health treatment in a confined setting. You would be a poster child for placement in such a facility. But no such facility exists. What we have is a correctional system, a prison system, or you're out in the community. And this court has to resolve today which of those two is better in this case. The court makes the ultimate determination that there are no substantial and compelling reasons for this court to grant a dispositional departure in this case. The legislature has determined that someone in your grid box who's committed a level 4 serious felony crime is to be presumptive prison. There's not enough here to overturn that statutory presumption. And the court finds that the court will deny the request for a dispositional departure in this case. This court has granted the minimum sentence under the Kansas guidelines for sentencing in this case. I've run the counts concurrently with one another, and I've granted you the mitigated sentence in this case of 38 months, and also noting that you've already served 236 days, about 8 months of that sentence, and you do have the eligibility to earn good time credit toward that sentence. So it's not going to be a very long prison sentence, Mr. Apple, but this court is going to follow the statutory presumption in this case and order you to serve your time in prison. And that is a controlling sentence of 38 months. I don't think there's a request here for restitution to the victim, Mr. Sweeney.
That's accurate, Your Honor.
All right. Of course, already dealt with the issue of jail time credit. The court awards 236 days, I think, is the proper computation as of today. And the sentencing journal entry should reflect the 236 days jail time credit. I will remind Mr. Apple of his obligation to register as a violent offender for a period of 15 years under the Kansas Offender Registration Act, dealing with periods where you are not incarcerated. I'll advise you, Mr. Apple, that you someday may have the right to seek expungement of these offenses. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant has a right to appeal their convictions to an appellate court having jurisdiction. And if such defendant is unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, Mr. Apple, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. Mr. Apple, I'll remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. The court will be assessing a felony docket fee in this case, and I think it's still appropriate for this court to assess to the defendant a $200 DNA fee. The court will waive bids, amounts, and all other costs given the court's prison order that it's made here today. Mr. Sweeney, I'm looking at my notes from this sentencing proceeding. Are you aware of any other sentencing related matter that the court still needs to address or readdress?
No, Your Honor.
Mr. Pate, are you aware of a sentencing related matter that the court has not yet addressed?
Is the court also considering and denying any request for a durational departure?
That was implicit in the court's announcement of its sentence, Mr. Pate. The court has denied a durational departure in this case.
Thank you.
All right. With all of that said, Mr. Apple, I do see in you a current willingness to take advantage of any programming that's available to you to get yourself better. I highly suggest that you continue to do that. First of all, that type of participation in programming in Department of Corrections custody will help you earn those good time credits against your sentence for an earlier release date. Furthermore, I would like to think that you're going to be in the best possible shape when you're released back into the community, so something like this never, ever happens again. Good luck in that regard, Mr. Apple. I hope you're successful in participating and doing well in those programs.
Thank you, Your Honor.
All right. Patricia Apple, I do appreciate your appearance here today and your addressing the court. Good luck to you in the future, ma'am. All right. If there's nothing further, then Mr. Apple will remain in the custody of the Butler County Sheriff's representatives until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 38-month prison sentence that's been imposed here today.
Well, 38 months. I don't know if that's not long enough or too long. But ladies and gentlemen, we're heading to Judge Simpson. And he had a pretty serious case, and we're starting that off. This is from Thursday. Then we're moving to a not so serious case from yesterday, and it all gets started right now.
Court does call the case of the people versus Christopher Dano.
Good afternoon, Your Honor. Michael Dobie for the people. Good afternoon, Your Honor. Douglas Gucci on behalf of Mr. Day is present to my right.
Your name?
Christopher D.
E. All right. All right. Date and time set for a preliminary examination. Are the parties ready to proceed?
We are, Your Honor.
All right. And I would just say that we had an in-chambers conference. There were some legal issues raised, and so the court may not finally rule on those today, but we'll take the testimony in the case. My understanding is that there's particularly an issue regarding the Sheriff's Department policies. I will take that testimony, and then this court can figure out if I ultimately determine that I cannot use it, then I won't. Additionally, if the court does determine that the policies won't be used as the basis for the misconduct, and I inform counsel of this, but can be used in order to, as some substantive evidence regarding the particulars of an element, particularly the corrupt nature of the actions, then the court may indeed take that testimony for that purpose. But so we can move this along, the court will hear the testimony and then make a decision later as to how it will be used.
Thank you, Your Honor.
All right.
With that, I would call Kurt Schifferkowski.
All right. Sir, please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony about you be the truth, the whole truth, nothing but the truth, so help you God. Take your seat. State, spell your first and last name for the record.
Kurt Schifferkowski, K-U-R-T, last name S-C-H-I-A-V-P-A-C-A-S-S-E.
Thank you, sir. What do you do?
I'm manager of the Washington County Sheriff's Office.
And how long have you been in that position?
In that position since 2021.
Okay. And before that, what was your experience in law enforcement?
Started off at the Sheriff's Office in 2001. Was a corrections officer, was a field training officer, was a sergeant, no war, ran transport and port security, as a lieutenant, went through the police and corrections academies, went to the MSA, special investigations, did some work at the AG's office.
Thank you. I'm going to have some questions about incident in the jail, Washington County Jail, March 18th of 2024. Okay. Now, before I get to that, I suppose, do you know the defendant in this case, Christopher D?
Yes.
And how?
I'll stipulate the identification and that he's a law enforcement officer in the employ of Washington County Sheriff's Department.
All right. Very good.
Appreciate that.
So stipulated.
We'll move along. Thank you, Mr. Gucci. When did you become aware of the incident in question here?
There was an email notification that was made at the time. D was a sergeant and he was working midnights, and I remember waking up and checking my emails the next day, and I saw an email notifying that there was a use of force in jail. Reviewed it, things stuck out to me.
Tell me about that.
What immediately stuck out was that the email indicated that Sergeant D sprayed a subject in the back seat of a police vehicle, an empty police vehicle, while she was in restraints.
Okay. That stuck out to you. What did you do?
Notified one of the lieutenants that we need to evaluate the situation when it came to work.
Okay. And so why did that stick out to you?
So ASR spray is used when somebody is a threat, and because she was in restraints in the back of a police vehicle, bars over the window, I had concerns as to whether or not that person was a threat at the time of the incident.
Could you tell what is ASR?
Aerosol subject restraint, commonly known as MACE.
Okay. And is that something that is issued to officers in the jail?
It is, sir.
Okay. And are there trainings regarding that?
Yes, sir.
That are required?
Yes, sir.
And are there policies regarding that?
Yes, sir.
And are there, what is done, if anything, to make sure that the officers know about the policies?
Anytime there's a policy revision or anytime there's a policy that's newly published, it's sent out in a program called Power DMS. The employees are required to review the policy and then electronically sign, and yearly aerosol subject restraint. There's a training course that's pushed through Power DMS where the students have to participate in the training, watch a video, and take a test.
Okay.
Successfully pass the test.
It's specific to ASR?
Yes, sir.
Okay. Approach with people's proposed 4, 5, 6, and 7, which I've shown to Mr. Gucher. Thank you. May I approach, Your Honor?
You may.
Commander, I've handed you people's proposed 4, 5, 6, and 7. Can you identify what those documents are?
4 appears to be an excerpt from the subject control policy. 5 is a use of force concept paper on the use of force continuum. 6 is an excerpt from professional standards policy. And 7 is an appendix that shows the resistance and control between the suspect and staff member.
Okay. And are those all Washington County Sheriff's Office policies?
They are.
Okay. You're familiar with each of those?
Yes.
And is it true that you had a hand in writing some of the use of force policies?
In the use of force policy, not the concept paper nor the professional conduct policy.
Okay. Your Honor, subject to your earlier ruling, I would move for the admission of people's 4, 5, 6, and 7.
Any voir dire or objection?
Just for clarification, those policies were in place as of the date of this incident, correct?
Yes.
No other objections other than the ones already noted by the court.
All right, very good.
Thank you.
4, 5, and 6. 4, 5, 6, and 7 are conditionally admitted.
Thank you. You mentioned that it's the incident that you were things stuck out to you because it was a use of ASR against someone who was handcuffed in the back of a police car. Is that right?
Yes, sir.
And generally, from the what is your understanding from the policies of the proper use of ASR within the jail?
ASR isn't classified anywhere in the force continuum. It can be used any time that the person that's applying force feels that lower forms of control will not be adequate.
Okay. Lower forms of control, what does that mean?
Muscling techniques, placing someone on the ground, escorting them.
Okay. Tell me about what you said, something about the individual not being a threat.
Yes.
Where does that fit in?
So ASR is used when there's a threat to staff or a threat to another person. And as the victim in the case was in restraints in the back of a police vehicle with bars on the window, it was difficult for me to see whether or not there was a threat to anybody else.
Okay. You talked about levels of clients using lower force to gain compliance. What does this mean, compliance?
To bring about a peaceful end to the situation, to bring about the lawful conclusion to an event.
Okay. When someone is, no, let's strike that. I'm not going to propose any hypotheticals there. Did you see, Commander, any justification for the use of ASR in that situation?
Objection relevance. Whether or not this officer sees that it's relevant is not the legal standard. Actually, under Graham v. Cards.
As to the form of the question, I'll sustain the objection. I'll allow you to rephrase the question, but I think as it's phrased, I think it's.
Thank you. In a situation like this, Commander Shipakasi, where someone is handcuffed and in the back of a vehicle, is that based on both your understanding of the policies and your own training and experience, a situation where ASR would be necessary?
Based on my training and experience, what I saw, no.
Okay. And why is that?
Because the person was not a threat at the time that ASR was used.
Okay. Talked about compliance. What was being asked of the arrestee at that point to comply with?
Answering questions as to whether or not she was suicidal.
Okay. What the 3 core questions that was referred to? What are the 3 core questions?
You have medical needs, you take medication, or any thoughts of hurting yourself.
Okay. And what is the purpose of asking those questions?
Just gauging whether or not they're going to be suitable into the jail to have the full medical evaluation done.
Okay. And if
Also gauge whether or not we can place that person on any kind of observation.
And if someone does not answer those questions, what is done?
It's not unusual. We bring them into the facility, search them, possibly place them on precautions depending on the situation.
Okay.
Cross-examinations.
Commander, briefly, were you going to get the individual out of the car?
I'm sorry, sir.
Were you going to get this individual question out of the car?
No, sir, I wasn't there.
Okay, so you weren't there, but you determined that there was no threat to the officers that were, correct?
Based on the circumstances.
Okay, were her feet restrained?
No,
What direction were her feet facing while the sergeant was talking to her?
I'm not sure.
Okay, well, if the feet were facing the officer, could that be a threat?
No, because she was in the back of
Okay,
the vehicle.
is that where she was going to be housed?
No,
Okay, so what do the officers have to do to house her?
move her from the vehicle.
Okay, so if they open the door and the feet are facing the officer and they're unrestrained, is that a threat?
No, that's typically how we get people out of the vehicle.
So you're telling me that it's not a problem for officers to be kicked?
No, I said that's how we usually get people out of the vehicle.
Right, but that wasn't my question. Is that a threat to have the feet unrestrained at an officer?
Depends on the circumstance.
Okay, so did you see the demeanor of the individual that was coming into the jail?
I did.
She was kicking the back of the windows of the car?
When she was on the way there, yes.
She was screaming, yelling, insultive, combative?
Yes, sir.
Okay. The officers have to make a determination to get her out of that car, right? How they're gonna do it?
Yes, sir.
Now, the 3 questions were just a precursor to getting her out of the car, correct?
Yes, sir.
The officers were actually there to extricate her from the car and put her in a cell.
Yes, sir.
Okay. Sergeant Day and one other person, what was the other sergeant that was present? Do you recall?
We was Sergeant Merrick.
They're the ones that are in charge of getting this individual out of the car, right?
Yes.
The other sergeant was a female officer, is that correct?
No, sir.
No? Were there female officers present?
Yes, sir.
And that was in part because not only do they work in the jail and handle all other prisoners, as a policy and procedure, you guys have female officers when available, deal with female.
When available.
Is that correct? And again, the ASR doesn't appear on the chart because you said that, and I want to get this quote right, not part of the continuum because it can be used anytime the officer feels or believes. And what was the rest?
Lower forms of control not be adequate.
Okay, no further questions.
All right, thank you. Any redirect?
One question, Commander Shipakasi, based on both the policies and your training and experience, is the preemptive use of ASR spray reasonable?
Given the circumstances, no.
Okay, thank you.
All right. Yeah. You may step out. Thank you, Commander.
Oh, Brian Miller.
All right. Sir, please come forward to be sworn.
You solemnly swear to affirm the testimony you about to give be the truth, the whole truth, and nothing but the truth.
Brian Muller. Muller, M-I-L-L-E-R.
All right, you may inquire.
And what do you do, sir?
Currently, I'm a special investigator with the Washington County Sheriff's Office.
And how long have you been doing that?
Since 2009.
Okay, and briefly, you have law enforcement experience before that?
Yes, I've been a certified law enforcement officer since 1974.
Okay, thank you. I asked some questions about an incident in the Washtenaw County Jail on March 18th of 2024, okay? How did you become involved in that?
I received a phone call from Commander Shipakasi stating that there was an incident that took place on March 18th in the Sallyport Correctional Facility at approximately 20 feet, 30 hours, involving WCSO personnel and an arrestee from the Tulane Police Department.
Okay, and was that arrestee Rachel Dameron Hissong?
Correct.
Okay. So you got this notification from the commander. What did you do?
I was instructed that they had some concerns, they being the administration, of whether or not the use of force was appropriate in this particular case.
Okay.
And, I was instructed to conduct a non-administrative investigation.
Criminal investigation.
Correct.
Okay. And did you do that?
Yes, I did.
Okay. And you could walk us through a little bit about the steps that you took in this investigation.
Well, one of the things I did was I had a liaison with the corrections division, a lieutenant that I asked to assist in some of the technical aspects of the investigative process by gleaning information from audio and video information that existed in a series of cameras. Initially, information from the Sallyport, then it was information from the body cams worn by Sergeant D and Sergeant Merritt, as well as information from the cameras in the holding cell, as well as information of the activity that took place.
Okay.
That was the first step.
Yeah, I'll stipulate to the admission of the, I believe we discussed body cam of Sergeant Day and the in-car camera from the point in time it reaches the Sallyport, the Washtenaw County Jail to the end of this incident, correct?
Yes.
Yes, stipulate.
All right. Thank you. That will be People's Exhibits 1 and 2. I'll ask one question. Did you also receive any records from the jail?
Yes.
Okay.
Okay.
Approach with People's Pros Exhibit 3.
Yes.
No objection, Your Honor.
To the admission?
Yeah.
Okay, I move.
You want the mugshot of the individual?
Yes. Could you just identify what that is for our record, People's Exhibit 3?
States on the front page, it's a mugshot profile, and it says Rachel Marie Damron Kassan, and it shows a picture of her front picture and a side profile. The second piece of paper says Washington County Booking Report, and it's a copy of the booking report from the date in question.
Okay. Move for the admission of People's Exhibit 3.
And I heard there's no objection, so Exhibit 3.
Okay. Jumping back to where you were, Mr. Miller, you obtained a number of videos.
That's correct.
And People's Exhibit number 1, which has been admitted by stipulation, is going to be the body cam of the defendant. And if you will give me a moment to connect. And I'm going to begin playing at 23:32:44, the timestamp in this video.
You just cracked the window. Hey, Rachel. Rachel. Hey, my name's Sergeant D. I'm the supervisor that's on shift right now, along with Sergeant Merritt. Okay. Hey, so I want to get you in, but I want to work with you. I don't want to. I do. I want to work with you. So let's just be honest. So I get paid whether you're here or not. All right, so here's the thing. I want to get you in the door, and we are having a conversation right now. No, we're not going that way. Are you suicidal? Are you suicidal? I'm asking you questions. Are you suicidal? I have been treating you. So, are you suicidal? Yes. Yes, I'm going to treat you with respect. Are you suicidal? Yes or no? My question. Do you have any emergency medical needs? Yes or no? I have been. Rachel, I'm trying to help you out. Answer yes or no. So here's what I'm going to tell you. I'm trying to get you taken care of, and I'm trying to work with you. I'm asking you, are you going to treat me like this? Do you have any meaning? I've already told you yes. Yes. This is the last time I'm telling you. Right now. Stand up. ladies. Lay down the stuff.
I'm going to stop the play there. We're at 23, 36, and 34 seconds on the timestamp of People's Exhibit 1, the Sergeant D's video. That was one of the videos that you obtained?
Yes, it was.
Okay. And reviewed?
Yes.
And what did you do after reviewing that video? Oops, I didn't mean to start playing again. I'm sorry. Commandership, let me start that over. That was a terrible question. Commander Shipakasi talked about things sticking out to him. What sticks out to you in that video?
Objection, Your Honor. Relevance at this point in time. He did the investigation. His opinion of what the investigation shows is irrelevant.
Oh, overruled. What sticks out to you?
Well, a number of things. And you talked about, as qualified by saying, one of the things I did in my career was I was a chief use and force instructor, as well as a ASR instructor. And so when I looked at the actions and the interactions involved in this interaction between Sergeant D and Ms. Hissam, I felt that it was problematic in terms of the actions taken by Sergeant D.
Okay, what do you mean problematic?
The use of ASR is for someone that's non-compliant, okay? And what I mean by non-compliant is that you've given them a directive, told them something specifically to do, you afford them a reasonable period of time to comply with that, okay? And you also give them a warning that if they don't comply with that there will be consequences, and subsequent to that, the ASR will be deployed. What I saw here was none of that took place. There was no warning given. There was no directive given. In terms of a threat to Sergeant D or anyone else, she was confined in the backseat of a patrol car, handcuffed behind her back, in a particular patrol car that has cages all the way around. What I mean by all the way around, both the side windows between the passenger compartment and the rear window were all caged in. And when we talk about imminent threat, okay, she was not posing at that time. She did not exhibit any aggressive, threatening behaviors that would necessitate the use of the ASR, nor was a warning given to her deployed with two other police officers in the front seat of the car. That's what was problematic for me.
But you heard her yelling at the officer and insulting him, right? You said that she wasn't doing anything.
So when we talk about ASR, what we're talking about is you want to gain compliance. Okay. Well, you have to have a directive to gain compliance. Okay, asking questions is not the same as giving a directive as I want you to do this. I want you to do that. We are getting ready to open the door. I want you to step out of the vehicle. Okay, none of that was given.
Okay. Tell me a bit about ASR itself, and you've talked about when it is appropriate to use, but what is the effect of it?
Well, it's basically a combination of like CS gas agent, a chemical agent that creates an irritant. Okay, so it momentarily incapacitates a person that will afford you the opportunity to take control of a person, and you hope that they will comply based on the fact of this irritant that has been applied to them.
Okay. Pain, right? It causes pain?
Absolute pain compliance.
Okay. what are the other considerations around ASR and the use of ASR that you were a trainer in? What are the other considerations?
Which you actually deploy it. In this case, it was deployed inside the confines of a occupied police car. And I say occupied, above and beyond the subject, Ms. Hissam was occupied by two fellow police officers in the Atlanta Police Department. And again, what I found to be problematic is that there was no warning given, so that they were equally being sprayed as well as Ms. Hissam in the confines of the car.
You also obtained the video from inside the police car, is that right? And that has been admitted as People's Exhibit 2 by stipulation. I'm going to move to that.
Community college, too hot shit. Oh, a year of community college, aren't you hot fucking shit? You're fucking pathetic. You're fucking pathetic. And fucking everything you asked for that fucking cunts. Shut up! Nobody's fucking talking to you, whore! Nobody's fucking talking to you, whore! No! Nobody is fucking talking to you, whore! Nobody fucking talking to you! Are you fucking done? Are you fucking done talking? You arrogant piece of shit! You are nobody! Are you fucking done? Are you fucking done? I'm just fucking done, dude! Do we want to fucking yet? Listen yet, you fucking whore! You fat, disgusting, ignorant, uneducated piece of shit! Swear fuck! Shut the fuck up! I keep it that way. Fucking worthless, fucking white trash, trailer park. How do I always get arrested? A fucking white trash, trailer park, hillbilly ass, useless, uneducated motherfuckers. It's unbelievable to me. It just blows my mind. You never get arrested by anyone with a fucking brain. You fucking evil fucking piece of shit. This team has nothing better to do with your time. Fucking go home to your wife. Go home to your kids, you fucking worthless piece of shit. Go home to your family. Go catch a rapist. Go catch a murderer, you stupid fucking redneck piece of shit. Fucking worthless piece of trash.
I'm pausing here at 23, 32, and 58 seconds. Mr. Miller, we've just seen someone outside of the window here. Is this when officers from the jail approached the vehicle?
Yeah, shortly thereafter. This probably I think within the next 15 to 30 seconds they approach the vehicle.
Okay, so up until this point, it has been the arrestee and the Ypsilanti police officers. Is that correct? Okay.
None of the WCSO personnel were privy to this behavior.
Okay.
Go catch a breakfast! Go catch a murderer, you fucking useless pieces of shit! What a worthless piece of fucking trash.
My name's Sergeant D. I'm the supervisor that's on shift right now. I'm on service. Okay. Hey, so I want to get you in, but I want to work with you.
You don't want to work with anybody. You want to make money for your little organization, and you want to split that money in this big rehab. So let's just be honest here. I'm a healthcare worker. You're a whatever the fuck you think it is. You are. Now here's the thing. You're gonna treat me with respect. That's the first thing. No, shut up. You're gonna treat me with respect, and then we're gonna continue. Are you gonna treat me with respect? I'm asking you a question. Are you gonna treat me with respect? Yes or no? Are you going to treat me with respect? Yes or no? It's a real simple motherfucking question. Are you gonna treat me with respect? Yes or no? You get the answer to your questions, you answer my question. Are you going to treat me with respect? Are you going to treat me with respect? Yes or no? This is a simple question. Then you can easily answer yes or no. Which is it?
Well, here's what I'm going to tell you.
Yes, you're still not answering the question. Literally, all you have to do is answer. No. You're trying to be a cunt. I'm asking you, are you going to treat me with respect? Are you going to treat me like I'm a human? Yes or no? Will I be treated like a human? You son of a fucking whore! You son of a disgusting fucking whore! You son of a disgusting piece of shit! You let me go! No!
And stopping there at 23, 35, and 15 seconds on the timestamp of the video. At this point, I don't believe I have any more questions for you. Mr. Gucci, are you going to want to use the video? Okay.
Cross-examination.
Special Investigator Miller, you're aware of the policies and procedures, at least in general terms of the jail as it relates to inmates who come into it, correct?
Yes.
And Central Dispatch will notify, that's why the officers come out to the Sally Port when individuals arrive, correct? In your jail?
Yes.
And in this case, during the course of your investigation, you did discern the Central Dispatch told the officers that there was an individual who was kicking the car and being combative, and they had arrived, correct?
Correct. YPD actually called it in and stated that information.
Right. So while the officers may not have been present for the entire event of the lady in the video, they were aware she was not being cooperative and kicking and such, correct? Had been. And you had the booking photo go in. I think someone had mentioned the video indicated she was there on FA.
Correct.
For the record, can you state what FA is?
Felonious assault.
Okay.
That was the original charge.
That was the original charge. I have no further questions. Thank you.
All right, any redirect?
No, thank you.
All right, you may step down. Thank you, sir. Any additional witnesses for the people?
No, Your Honor.
All right, any witnesses for the defense?
No, Your Honor.
All right, we had a previous bench conference, and I'm not sure how council wants to do this. I can certainly hear the bind over motion now and then argument. Or would you like the opportunity to submit positions that you have in writing to the court prior to the court making its ruling? Whichever way is more convenient for council.
I'll defer to Mr. Dobie.
I'm happy to argue this now.
All right, very good.
Your Honor, the facts are pretty simple in the case and are not really in dispute based on the cross-examination that happened. Rachel Dameron Hissong was arrested for an offense, brought into the jail by YPD, and was a jerk. She was yelling and and making a scene in the back seat of the car, as we saw in the video when she first got to the sally port. But it's the behavior of the defendant that's a question here. And we saw him approach the car, attempt to ask several questions, give no commands, not asking her to do anything, and not being any type of threat from this person. So setting aside for a moment that this is a police officer and all of the responsibilities, duties, and trusts that are placed in him, this is a person who is handcuffed and within a cage in the back of the vehicle who has a weapon used on her, that weapon being the ASR spray. That is an assault. It is a felonious assault based on the type of weapon that the ASR has been can be found by a trier of fact. A jury can find that is a dangerous weapon and how it's used. It was sprayed directly into her eyes, obviously causing significant pain based on the video, and the jury could find that it meets the definition of a dangerous weapon and that it could cause a serious injury. But he was a police officer. I'm sorry, not a police officer. He was a corrections officer at the time who did have, who was there acting under the color of his office, performing or supposed to be performing duties of taking this woman into the jail. And his behavior by spraying her in the face when she was no threat, when she was not refusing any orders, when she was just not answering questions that Commander Shipakasi says happens all the time, that people do not answer those 3 core questions. She's not answering the questions and she insults him and he sprays her in the face with the ASR. That is a wrongful act. Going through the elements of misconduct, he is a public officer. He meets that definition. That's by stipulation. He was there. He was working, acting under the color of his office. The only issue at this is the corrupt intent. And for that, we've had some testimony and admitted some exhibits, obviously subject to the court's later ruling on them regarding those duties and responsibilities that are placed on officers and the trust that is placed on them for the people that are put into in their custody. By flagrantly violating all of those, spraying someone who was handcuffed and in the back of a police car, goes to show that his corrupt intent. He knew that what he was doing was wrong. He knew that he was trained in it. He had to be certified in this every year, and it goes against that trust that we put in people in his position for the basic humane treatment of people that are put into our jail. All of the elements of each crime have been proven to the standard necessary for bind over, and I ask that you do so.
All right. Just one question.
Yes, Your Honor.
Had this say the door had been open, either side, doesn't matter, and the arrestee is now out of the vehicle, and let's say is thrashing around, we wouldn't be here, I guess.
I'm not sure
and then the deployment of the ASR.
I'm not sure that's I mean, in your hypothetical, she is still handcuffed. She is still a restrained person and within the jail, kicking and thrashing around. I think that that there might be an argument that the use of ASR or other force is necessary, but in this circumstance, there's 7 officers around that car. Someone kicking and thrashing around happens often, and they are not sprayed while they are restrained.
Got it. Okay.
Yeah, the standard preliminary exam is simply they have to produce evidence to the level of probable cause, or evidence that probable cause to each element could be inferred from the evidence presented. In this case, you have two unique charges that, by the circumstances, present themselves here. First of all, my client, by stipulation and by fact, at that time was a law enforcement officer working as a law enforcement officer, which means by law, there's certain things present for consideration for this court that's not present in the normal course of an assault and battery case. Graham v. Connor is the standard by law. An officer is given greater latitude to use force in the course and conduct of his employment. In fact, that court says the law recognizes law enforcement officers are required to make split-second decisions of life and death, which cannot be judged through the 20/20 vision of hindsight from the vantage point of judges on the bench, or for that matter, other officers who would have done things differently as they're sitting in an office reviewing the actions of an officer the next day. Even the policies and procedures of the Washtenaw County Sheriff's Department, which prosecution entered into evidence in this case, indicates that the officer makes the determination. What Mr. Miller left out and was already admitted into evidence in the general rules is that the AR spray, while it says employees shall provide a warning prior to deploying a chemical agent, if doing so does not increase the risk to the employee or another person, which again leaves discretion to the officer involved. Commander Shipapakasi testified that the use of force in an AR spray does not fall on the continuum of force. It's left to the discretion of the officer to use based upon the facts and circumstances as they see them. So take all that into consideration. How does that apply to the first charge of assault with a dangerous weapon? First of all, there was no assault because his use of the tools that were given to him for compliance were lawful. That's what he's supposed to do. That is the purpose of the AR spray. No officers in that video were injured. The individual did not sustain any serious physical injury and was not subject to death. The individual was removed from the car and taken to a cell. If you look at the facts surrounding it, they're trying to create that there was some type of retaliation by Sergeant D. There was no retaliation. He was very patient with this individual. The decision not to issue a warning appears, based upon the video, to be more in line with extracting her from the car in a safe manner for both him and his officers, which was successful. There was no abuse of this prisoner. The prisoner's legs were not restrained. The prisoner's mouth was not restrained. Every day, this court and law enforcement deals with situations where officers are injured by individuals, as you just gave in your scenario, getting out of the car and starting to act in a manner in which officers could be subject to injury. In this case, he short-circuited. The individual was not there for a white-collar crime. She was there for a felonious assault. The officers were made aware she was being non-compliant, combative, and kicking in the car prior to them ever going out there. Her actions in refusing to answer created a situation where Officer D, under the law, made a reasonable determination to extract her in the safest manner possible, and it was successful. In order for him to be bound over for assault with a dangerous weapon, they would have to prove by at least a preponderant or a probable cause level that a dangerous weapon was used in this case. By court, the standard jury instruction, a dangerous weapon is any object that is used in a way that's likely to cause serious physical injury or death. There's no probable cause presented in this case to show that the use of that pepper spray in this mace in this case would have caused serious physical injury or death. The facts and circumstances that are predicate to find that it was a dangerous weapon, there's no probable cause. That can't be bound over as presented to this court. The court rule, the standard jury instruction continues to say some objects such as guns and bombs are dangerous because they are specifically designed to be dangerous. Other objects are designed for peaceful purposes, but may be used as dangerous weapons. The way an object is used or intended to be used is an assault determines whether or not it's a dangerous weapon. In this case, because this is not a standard delineated by statute dangerous weapon, the court first has to find probable cause that based upon the facts of this case, that this pepper spray was in fact, at least a level of probable cause, a dangerous weapon, which I don't believe is present. Now go to the misconduct in office. Again, based upon the facts, they can disagree with how Sergeant D did his job that day, but that's just second guessing. You know, there's no depravity shown here. There's no corrupt intent. There's no perversion. You know, the court rule, proposed court rule that was provided by the prosecution in this case The word corrupt is defined as depraved, perverse, tainted. I mean, that's not there. Corrupt intent includes intentional, purposeful misbehavior related to requirements or duties. What's interesting is even with the policies and procedures and testimony, nothing was intentionally against the policies and procedures. Policies and procedures do not require a warning if the officer deems that it could put someone at more risk than they're in. And there's no prohibition on using the ASR spray. So they didn't even prove that there was anything for their purpose of showing corrupt that he didn't follow policies and procedures. They didn't even show that. And then if you take the facts of the case as presented, he used one burst of pepper spray that's issued to the officers to gain compliance and to ensure safety of the officers and the individuals. He did that to get her out of the car.
What was he gaining compliance to?
To get her out of the car. That was it. He wanted to get her out of the car in a manner in which she didn't fight with the officers and the officers weren't hurt. And it was successful.
As I look at it, how would I know she wasn't going to comply with that?
You wouldn't. But if the officers take her out and they're injured, then you're second guessing saying, why didn't you use the pepper spray to get her out? Because that's why you have it to distract her.
No. But I would
Judge,
be
I
second
haven't-
guessing. Would I?
Yes, because that's why we're second guessing now.
No, I don't think we're second guessing. I mean, the issue becomes that he didn't ask her to get out of the vehicle.
He doesn't have to.
He doesn't say, we're going to take you out of the vehicle.
But Judge,
He keeps saying he doesn't have to.
Right.
Counsel, just because you say it doesn't make it true. What he does, what you're arguing to the court is that the officer, upon some assessment, can take some preemptive strike because he believes that something is going to happen that hasn't yet happened.
Well,
I'd like to see, there's a
even
case law that gets me
the
there.
policies and procedures provide for that. They can use the level of force that they believe is necessary. It's left to the employee's discretion. And it's enumerated in there. There's active resistance, passive resistance. There's, if an individual is combative physically, or if they're just refusing to comply. Now, in this case, you're saying that he should have said, hey, we're going to open the door and take you out. Well, she was at the jail. Okay. Well, I mean, you're not saying that specifically, but you're saying, why didn't he open the door and see what she would do? And if she opens the door and he kicks him in the knee and blows it out, we're saying, well, you don't know that would happen. It happens in the jail all the time, Judge. All the time.
But the thing is, that would mean that anybody who is in the back of the vehicle, an officer would be correct, or at least could properly, anybody coming in, whether they're screaming, yelling, doing anything, if they're in the back in all kinds of restraints, I can spray them or do something to them under the notion that something might happen when I open the door.
I think that may be correct. However, in this situation, he's charged with specific crimes. There are other crimes that they can be charged with, theoretically, that wouldn't be assault with a dangerous weapon, i.e. a weapon that could cause serious physical injury or death. That would be a simple assault and battery. And an individual can be charged with assault and battery without being charged with misconduct in office, because while it may rise to the level of an A and B, it doesn't rise to a level of depravity, perversion, or corrupt intent. There's levels to this. The reason we're here is this is a felony charge in which they have to have probable cause for the charges they issue. That doesn't mean that another charge may not be more appropriate. These charges are not appropriate. And that's what we're here on today. And yes, officers are given great latitude to do their job. That is the law. Graham v. Connor, 2020 hindsight is not the standard. Can't second guess what he did. In fact, the court says unless the use of force is arbitrary, the officer has discretion. This is reading from People v. Sure. The officer has discretion within reasonable limits to determine the amount of force which the circumstances require. And he's not guilty of wrong unless he arbitrarily abuses the power confided in him. It's one of the cases I gave the court. It's a quote from the court. These are special circumstances based upon the fact that the officers work for the public, and their job is not necessarily second guessed. Force is part of their job on a regular basis. The charges in this case are not appropriate. And as such, there's not probable cause to in the first case.
Okay, whether or not the actions meet that what's charged.
Correct.
I guess I'm asking from a factual standpoint. What you're arguing is that anybody brought into the jail, doesn't matter what they're doing. You're saying that the court, if an officer responds the way that the defendant in this case has to somebody in the back of a vehicle, regardless of what they're doing,
No, Your Honor.
that they're provided that latitude.
No, Your Honor.
Okay, what
I'm saying is, as long as their actions aren't arbitrary. If you just decide that an individual sitting in the car is brought in, I'm going to spray him, that's an arbitrary use of force. But that's still not necessarily a felonious assault, and it still might not be misconduct in office. It may be a policy violation. Not every action is a criminal violation, Your Honor. And the officer, under the law, as long as his actions are not arbitrary, then yes, it's legal. That doesn't mean that it's not excessive. That's called a civil action. 1983 action. There's a whole list of things that officers aren't allowed to do that still aren't criminal, but they're charged in civil court all the time with violations. Officers are given special treatment. And as long as his actions weren't arbitrary, if there's a reason for it.
Yeah, counsel, I get that they're given special treatment. I know the law in that area. I guess my question is, that's not sort of carte blanche.
It's not.
And so the question becomes, in this case, where are you drawing the line? Because the only reason we're here is one side's drawing the line here and one side's drawing the line here.
But that'd be a factual issue, which I don't want.
I'm trying to figure out where your line is.
My line on the first one is, it's not a dangerous weapon.
Okay.
Okay. So therefore that charge shouldn't be bound over. On the second one, it's not corrupt intent. There was no perversion. There was no depravity. If you're using the policies to say that there was corrupt intent or depravity, the policies say it's up to the officer's discretion that they can use the ASR. They don't have to give a warning, as long as, there's
If the court would determine that a reasonable fact finder could conclude that it was an abuse of their discretion, does that then give rise to the potential that?
I would say no, because then you're basing the decision to bind him over on the policies and procedures and not the action. See, this is the dilemma that we talked about. Yeah.
You're not, that's not true. What you're saying is that the discretion of, it's really the discretion of the officer. That's what the policy is. I'm saying if one were to determine that it's an abuse of discretion, that equates to that depravity that we're talking about, or some corruption because it's an abuse of discretion.
No, that would mean
that be for the fact finder to determine.
I think you're mixing, in my opinion, Your Honor, I think you're mixing two different concepts together to get.
No, I think you are in trying to run me in a circle, because what I'm saying is if I take the policy.
Correct.
And I take that policy and I say, yes, they have discretion.
Correct.
But a reasonable fact finder could conclude that this is an abuse of discretion, which could be used as a factor to determine whether or not there's depravity or corrupt behavior.
Well,
that,
Your Honor,
then
I'll leave it.
Go ahead.
You to go and make your own determination. I'm not going to be able to change your mind necessarily on that. I think we're going kind of in circles, but I will direct you to the People v. Milton case, which is the assault and battery and the misconduct in office charge, which kind of started this whole thing in 2003. And in it, it kind of addresses your first part that you're kind of coming at me with this question. And it said that if our holding will strike fear in the hearts of police officers throughout the state, that no public officer under the color of his office will feel entitled to behave in the egregious manner that this defendant did, it would achieve that result. So that it's saying to us that if our concern is that officers, when every time they use force, is going to be left to a jury to decide if that force was arbitrary and whether or not it's misconduct in office, the court says to the first part, if it's like this case, if it's horrible like this, what Milton did, then that's going to serve our purpose. But they go on at the end of that paragraph and says, listen, The defendants fear that in light of this result, any malfeasance on the part of officers will be construed to misconduct in office is unfounded. Only malfeasance committed during the existence of a duty under the office or under the color of the office and results from corrupt behavior constitutes misconduct in office. You know, and I think in this case, if you look at that, there was no corrupt behavior on the part of Sergeant.
That was one of the cases that you presented to the court. Okay.
This isn't corrupt behavior. Milton, he beat the inmate. He hit him repeatedly, knocked him down, slapped him, hit him. This was an individual where the court, the witnesses, the prosecutor, they may all disagree and say you should have done it differently. But there's different levels to this. This is a criminal court with specific elements. You know, there's administrative proceedings, civil proceedings, and other proceedings which you can address perceived wrongdoings. This is a criminal in which an individual's liberty is at stake. And they have to have probable cause to each element. I'm not asking the court to condone his conduct. You may disagree with what he did, but I'm asking you to find and hold them to the probable cause level of each element in this offense. Thank you, Your Honor.
All right, thank you. Mr. Dobie, anything?
Yes, briefly, Your Honor. First, I would ask that the court not place any reliance on the Graham case that was cited in the standard set there, because that is not applicable to criminal law in the state of Michigan. It is applicable in civil cases, but not in criminal cases.
Well, I use that jury instruction repeatedly. It is adopted by the state of Michigan. It is the use of force, and I have standard jury instructions that your office provided me, in which quotes that standard.
And as we go on, without belaboring the policies too much, I will just go on to the next paragraph of the policy that's cited. ASR can be used to subdue an unarmed attacker or to overcome resistance that is otherwise likely to result in injury or either the subject or the employee. ASR devices shall not be brandished as a form of intimidation. That is the policy on ASR. That is what he's trained. That is what he is supposed to be doing here. And that is absolutely not what happened in this case. It was malfeasance. It was, the intent was corrupt. The committee on model jury instructions says to look at People versus Kotu for the definitions of that. A tainted or perverse use of the powers and privileges granted to him. Tainted means a trace of something bad or offensive. Perverted means misguided, distorted, misinterpreted, turned from what is considered right or true. We expect that officers will exercise their duties in a manner that is fair and equitable. Doing the opposite of that is what is meant by corrupt intent in a misconduct in office case.
All right. Counsel, I want to make sure I take a look at everything that you presented to me, and I will give you another date to come back. I know my schedule's kind of tight this month, but I can do any Thursday in the afternoon. Would April 3rd work?
Yes.
It would? Okay. So what I'll do is I'll turn this out, preliminary examination for April 3rd. It's my PCC day. I have no idea right now what it looks like. I'll just put it at 3 p.m. if that works for everyone. All right. All right. Defendant's bond will continue. Counsel, did you get a copy of the order? I did.
Ask the court.
I didn't.
Okay. Yes, I signed it. So
Signed.
yes, I'll give the parties, there's a copy for each of the parties. And, you know, I haven't rendered a decision on this, but I want to compliment both counsel for shortcutting the issues, getting right to the point. And actually people should probably watch. I'd love to have younger attorneys watch the two of you and how you operate with respect to each other in a case. And I mean that from the bottom. Thank you.
Just one question, does the court want to retain the?
Yes, I need the exhibits. Yes, I need the exhibits.
Judge, do you want to just verify what's I've got 1 and 2 on here, the full video. Okay.
All right, so if I have that, you're gonna get those.
May I approach?
Yes.
There's 1, 7.
And 1 and 2 of them. Got it.
Yeah, they're on there, and everything that we do has to be encrypted. So the password is right on there.
Got it. Okay. Understood. Okay. I think I put my date in. Yes, I did. Okay. And then, Mr. Wonders, I'm going to take a brief recess and come back with our last matter. J Group Holdings versus Azar Stafffield. They did say.
Good afternoon, Your Honor. Plaintiff Anthony Momena appearing on behalf of plaintiff Charlie Bowles.
Good afternoon, Your Honor. Azar Stafffield.
Your interpretation. In this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
Well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case, because she had changed the caption. They were to be refiled and served.
They were not.
Was that done, ma'am?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court we did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes, we
My sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Did we get a new file? Yeah, because if she filed them and served them, they would be in my court file. And it's odd, I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it, but she's telling me she didn't.
So according to GIS, today an answer and motion to dismiss was filed.
That was
Not by me, Your Honor.
Yes, okay, I see that, but that was not the original.
I have not seen that.
Service on here, I don't. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead. We did the same thing we did the last time.
May I show this to you?
No.
This.
You did the same thing.
No. This notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case?
That was
and not sign it.
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go ahead.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to.
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I am not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney.
Okay.
That's licensed to practice
Okay.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right.
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Okay.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly. just briefly. This is not a rent case, Your Honor. This is
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. That the backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy, and I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in the incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started. If at all the court would go along with us, let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of
No, you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay. I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy. Okay? This loan shark and his attorney are trying to
Are you almost done?
Yes,
Good.
to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not going to yell when you're in here. You're not going to whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
You too, sir.
Thank you, Judge.
Can you, do me a favor, can you go out there and just make sure they don't like.
Wow. So, the last cases of the day will be with Judge Middleton, ladies and gentlemen. And we're going to stick with the landlord-tenant theme. And this time, we've got a landlord who's a little out of sorts and some tenants who are a little out of sorts. Right? You know, either way, it all starts right now.
All right, we have two landlord-tenant matters to start this morning as non-payment of rent. One is Jim Jehosa and the other is Michaela Baker and Gabriel Houghton. Our first case is 9 a.m., which is James Jehosa. You said it Jehosa?
That's correct, Your Honor.
Mr. Thompson is not here. This is his party. He filed the action. He's not here on either of your cases. Mr. Jehosa, have you paid the rent?
I became unemployed and I had they gave me 5 days to vacate. I've had a great relationship with Mr. Thompson, done tons of work for him, and I vacated within 5 days. And the 1 month that I was, because we were on a month-to-month that I was late, I accepted. I told him I would pay him as soon as I got back to work. He said, well, I can't have you there living rent-free. I said, I completely understand. I said, can I get 30 days? He said, no, I need you out in 5. I said, no problem. I've got pictures. The place is absolutely spotless. And I told him he could take the $800 security deposit that I had toward the 1 month rent, which would negate it. And he said there's additional court fees for $176.50. I said, I'll go ahead and I'll pay that when I have it. And he said, tell it to the judge.
He's not even here. He can't give you 5 days to vacate. He has to give you what a rental period is, which would be 30 days. He gave you a 7-day notice to quit, but your rent is month to month. So he needed to give you 30 days and he can't kick you out. I can. Just because he tells you you have to leave, it's not up to him, it's up to me. So you would have been entitled to have a hearing, but you have vacated?
Yes, sir. Yes, Your Honor.
Well, he isn't even here, so you got to tell it to the judge, but he's not here. He's not, doesn't have a lawyer, and he doesn't seem to completely understand the Landlord-Tenant Relationship Act. Defendant has vacated. Plaintiff fails to appear. Well, here he is. Mr. Thompson.
Somebody else right now.
All right, Miss Martin and Mr. Smith just remain quiet. Mr. Thompson, can you hear me?
Yes, sir, I can hear you.
All right, you're 8 minutes late for your hearing. We've been stalling for 8 minutes. And if you can't appear by Zoom, I can have you come in live and in person.
Yes, sir.
Your first client, Mr. Yehosa, says you told him he had 5 days to move. And he couldn't stay there for free. So he says he has vacated.
Yes, sir.
That isn't how it works. He had a 30-day month-to-month tenancy. You were required to give him 30 days notice. You gave him a 7-day notice to quit. So you're representing yourself, but you don't really understand the law very well. And then you show up late, which does not make me very happy. Anyway, he is vacated. He's no longer there. You did file a supplemental complaint for money damages. As he indicated, he was going to allow you to take the security deposit for back rent. Mr. Yehosa, he did pay the fee for supplemental money damages. So after you vacate, you need to turn in your keys and give your forwarding address in writing within 4 days of moving. Have you done that?
Yes, Your Honor. I did that via text to Ben, gave him my address. He asked me for that.
All right. Well, you vacated. There may be a subsequent hearing regarding money damages, but the possession case is dismissed. Defendant has vacated. Do you agree with that, Mr. Thompson?
Yeah, yes, sir.
All right. Once you take possession of the premises, you can determine what you're going to do. And if you wish to file a claim for money damages, you can do that.
The claim, sir, for the money damages, the claim should already be included with that filing as well. There's a couple things. And one, I do apologize. I had some computer issues on the VPN this morning. So it took a second to figure out, but so my apologies on that. So, but the second piece of that is that the filing, the judgment for monies should be filed already and included with that paperwork.
It's not. You could really use a lawyer to help you with this. You didn't file the right side of thing. You filed a detail of expenditures and a couple pictures of some stuff, but that doesn't amount to a claim for supplemental damages. You've got to list what it is, how much is rent, how much is utilities, how much is court costs. So just adding some paperwork. If you're in the landlord association, which you certainly should be, Ms. Richmond can help you with that. She does a good job with her supplemental damage complaints. So,
Miss Richmond, sir, Miss Richmond did assist me with this. So I'm not sure what paperwork, if there's paperwork missing there. We walked through the entire packet. She's got a packet.
Yeah, there is no complaint for supplemental damages. You said you paid the fee for it. You filed a demand for non-payment of rent. You filed a 7-day notice to quit on a 30-day tenancy.
Come on. No, come on.
I don't want to listen to that. So anyway, you could file a supplemental complaint for money damages.
In there.
And
come on.
Ms. Smith, I'm going to put you and your dog in the waiting room until we deal with your case. At any rate, he's moved, so the possession case can be dismissed. Mr. Joseph, we aren't done. There's a money damage case we still need to do. And Mr. Thompson, you agree he's given you his forwarding address?
We did a validation on the postal records, Your Honor, and that address is not registered to his name.
It doesn't have to be registered to his name. Do you get mail there, Mr. Joseph?
Yes, Your Honor.
All right. This matter is dismissed. We'll address it further when it comes to the issue of money damages.
Thank you,
all right,
sir.
You're free to go. All right, next is Benjamin J. Thompson versus Michaela Baker and Gabriel Houghton. They are here. This is also filed as a demand for non-payment of rent with the complaint for supplemental damages. How much is the due in rent?
If you just give me 1 second, I'll flip over my paperwork here.
I'm going to ask you that question every time. How much is rent? How much is utilities? And then we'll calculate court cost.
Okay, I included a list of expenses and receipts as well as the rent. Just give me 1 second. I'm gonna go through it here.
All I want right now is the rent. You filed this as a demand for non-payment of rent. If they paid their rent, they would get to stay there.
Okay. Back monies owed for rent was $1,037.50.
Through when?
That was a couple months ago. I guess it would have been through February, Your Honor. So they basically got 1 month behind on rent, but then in addition to that, once they moved, we found a bunch of damages, and so those were listed in the list of expenditures.
All right, well, this is filed as a demand for non-payment of rent. We haven't got to the damage part yet. You did list waste management, container removal, liquidated damages, Ashley cleaning and painting, $650, painting supplies, $49, back rent, $1,087. So what you're asking for is $3,756.18.
That's the total of the damages, as well as the receipts. I also provided pictures there as well.
All right. We'll have a hearing regarding that, but we're not there yet. This is the possession hearing.
Understood.
Now, Mr. Houghton and Miss Baker, it looks to me these pictures are terrible.
And
make me want to get out of the landlord business.
We only have 48 hours to get out as well.
Tell me about that.
I was gonna be going to work that morning. We got a call from them. Was told to get out. I had called my cousin up. We had got a truck and we moved everything out. The damages, I apologize for. Most of it was because of how narrow the hallways were when we would move furniture. Scuffs and whatnot would get on the walls. We moved everything out and gave him back the keys.
Did you give your forwarding address?
Yes. To a text message.
All right, here's how it's supposed to work. Your landlord doesn't call you up and say, hey, you got 8 hours to move. Your landlord serves a notice to quit on you that says you have 30 days to pay the rent or move. If you don't pay the rent, then he sets a hearing before me, the first initial hearing, which is what this is. Then the law says you get 7 days from that day to have a second hearing to either try to get some financial assistance or some legal assistance. If legal aid was here, they would be having a field day with Mr. Thompson's failure to follow the law.
Sir,
At any rate, then you would have 10 days from that day to move, or you would be subject to being evicted. So in both of these cases, the tenant represents they were given less than 30 days notice to move.
They're both
Now,
incorrect.
by the same token.
That's both incorrect, Your Honor.
All right,
Respectfully.
well, stop interrupting me. I'll give you a chance to speak. This is their version. Anyway, they moved out. So again, the possession is unaffected and it's dismissed.
Respectfully, sir, that you have the notice to quit as well, the 5-day and the 10-day. And before that, we also received calls from both the city of Three Rivers due to the fact that there was issues from tenants that they let move into there that was against their lease. The people that moved into there prior to that, I'm surprised they haven't mentioned this at this point, Miss Baker and Mr. Baker. That,
well, you didn't file a termination of tenancy. You filed a demand for non-payment of rent.
I did. However, the people that were there and damaging, which they haven't mentioned, they basically let move in with them. So the damages were accumulated from both of these people. There were more than 4 or 5 kids living there at the time.
Well,
that I found out.
They trashed your nice apartment. These apartments above the stores are very nice. And I didn't like looking at this. It looks like somebody treated it like they didn't care at all. So I don't like it. But you didn't file a demand to terminate tenancy. You filed a demand for non-payment of rent. So if they had paid the rent, they would have actually been able to stay there. And so they had already vacated by the time you filed this, I think. But I'm going to give you your hearing regarding money damages. We'll take testimony under oath regarding how much damage there was. We'll apply the security deposit and add court costs and hear what they have to say. But this isn't the time for that. We'll try to set both of these for a damage hearing at the same time.
Understood.
Your Honor.
Yes.
He did give us paper to where he said if we paid rent within 7 days, we would be able to. And we had the money to pay that Friday. I let him know that we would have the money on Friday to pay. That Friday, before the 7 days was up for the payment of rent.
All right, well, we'll explore that further at the damage hearing, but you left this place in deplorable condition.
We had 3 days.
Yeah, we were out of there, and we were out of there in a day.
The reason
Paul and I grabbed everything that was ours and we left.
Sir, respectfully, the reason that they left was because that they were under conditions that they with the police when they got called out for a domestic abuse case, that they had issues with the tenants that they allowed to live there with them.
All right,
So they said they left in 3 days due to that fact. By the way, they were calling me asking me what they should do to get these people out of their apartment because they let them in.
Who were the other people that were in there?
They were friends of ours.
What are their names?
Carrie Haney, Isabella Clark, and I don't know Ben's name. I'm sorry.
So you let people move in, you don't even know their names. They help trash your landlord's apartment. There's going to be some significant money damages here. but we'll set that at a hearing. We'll block out at least an hour, maybe more, for testimony under oath. And hear both sides' final story. But as far as possession goes, he already has possession back. So the possession case is dismissed and we will have a money damage hearing. Where we'll hear both sides under oath. All right. That will be set probably either before the end of this month or early April. All right, thank you. You're all good to go. Mr. Thompson,
Yes, sir.
could use some legal advice here.
Yes, sir. I talked to Miss Richmond about this already. The last lawyer that I brought in there with you did exactly what you and I are doing right now. We went through the same headache, so it just wasn't worth it. If you got somebody that is worth it for me to actually make sense, then I'm happy to use them.
Well, you do have a right to represent yourself as long as this isn't a corporation or a limited liability. If it's just Benjamin Thompson, owner, you can represent yourself. But it's just, it might be worth it to have counsel. There are a number of attorneys that do this, and I can't specifically, but Ms. Richmond knows who's good at it and who isn't.
I understand. I'll give her a.
But it's up to you. You do have a right to represent yourself, and maybe when you do more of it, you'll get better at it. But right now, we got some bumps in the road.
I understand.
All right, Mr. Gahosa, when we do this the next time, you can't come by telephone. And I expect everybody to show up on time. We're already late because I sat around for 8 minutes or 9 minutes waiting for Mr. Thompson to come. So everybody else is backed up too. So when we do this the next time, you need to have a video connection and you need to show up on time. So I'll see you at the next hearing. We'll do both of these on the same day for your convenience, Mr. Thompson.
Understood.
All right,
Thank you, sir.
All right.
Your Honor,
Yes.
I just wanted to make sure it was okay that I leave.
Yeah, I'm going to remove you now.
Okay, thank you.
Ms. Yost.
Thank you, Your Honor.
As well.
Well, kids, that's where the show ends. Been a crazy one. I wanted to end things on a little bit of a brighter note. So we have several things to check up on. We have these Middleton cases. Check up on, see how we know how they're all going to end. But that landlord guy, man, like I think Barry said it, every time he's in there, it's the same crap. Middleton keeps telling him to get a lawyer. He comes in, doesn't have a lawyer. Same crap every single time. But at least it's better than the way we started off, right? At least we're not dealing with that special kind of crazy. Ladies and gentlemen, I am your Lone Wolf Usul. I'm your host for these here videos. I am your curator for the court gallery. I put out videos every single day, all day. Come by and check me out. I'll have some things coming out later on today, tomorrow. Most especially, come hang out with the live chat on all weeknights, starting at 9 p.m. Eastern Time, 8 p.m. Central Standard Time. Central Time. Daylight Standard now. Whatever. Guys, I love you very much. Without you, I am nothing. You are my favorite people to hang out with on every Saturday, and we do this every Saturday morning starting at 11 a.m. Central Time. That's noon Eastern Time. Come by and check us out here at the Court Gallery. This is live from the gallery. I'm your Lone Wolf Usul. Thank you very much for hanging out with me. Y'all have a great Saturday. Have a good weekend. Be safe, and we'll see you next time.